Okay, hello everyone. Welcome once again. Thank you for joining us. We're really excited about the incredible turnout we had for this today. Obviously, everyone has a lot of questions, and hopefully, we'll be able to answer most, if not all, of those today. But you can always refer to glad.org/DOMA and gladanswers.org for more information. I just want to give you a brief introduction. My name is Amanda Johnston. I work here at GLAAD. And before I turn you over to our fabulous presenters for dollars and cents filing taxes after DOMA, I just have a few things to walk through. First of all, just a bit about GLAAD. Gay and Lesbian Advocates and Defenders is a legal advocacy organization. We work primarily in New England, but also federally to advance LGBT and HIV community legal rights. And you can find more information about us at glad.org. We were on the forefront of the legal challenges to the Defense of Marriage Act, so we're really happy to be able to share with you information about what it means that DOMA is now gone. And a reminder again, GLAAD Answers is here to answer your specific questions. If there are things we don't get to today or you have more questions about federal taxes or any other issue, please contact us either at gladanswers.org or the phone number that you see on your screen, and we will be happy to work with you. I want to thank our many community partners who helped us get the word out about this webinar today. You can see all of their great logos and names up there on the screen. And we really appreciate all the great help that they provided and that the services that they do out in the community. And just a few reminders before I turn you over to our presenters that this webinar is being recorded. We are going to be sending out to everybody who registered an email with a link to the recording and all the slides and other information that are referenced in the presentation. That should go out tomorrow. You can also visit glad.org/DOMA to find that information as well again after tomorrow. So with that, I am going to go ahead now and welcome GLAAD staff attorney Janson Wu and CPA Lillian Gonzalez, who are our great panelists today. And they are going to take it away from here. So Janson.
Thank you so much, Amanda, and welcome everyone to this helpful webinar. So I just want to reiterate one of the, and hold on one second, now you can see my screen. I just want to reiterate one of the things that was on the first screen, which is that this webinar is here to give you important and helpful information about federal taxes, but is not intended to be tax advice in any ways. So we very much do recommend that if you have specific questions about your specific tax situation, to contact a tax attorney or a CPA, such as Lillian Gonzalez, who I am really excited and thankful for her to be joining us on this webinar. She is just a fountain of knowledge on this topic. She is actually my own CPA. And Lillian, I promise you, I'm getting my tax documents to you very soon. We're still waiting on Adam's W-2s that are sitting on our dining room table.
Great, thank you.
Thank you, Lillian, for joining us. So I'm going to be starting, I'll be giving a little bit of an overview, and then I'm going to hand it over to Lillian, who's really going to get into the nuts and bolts of what you can expect and what you should know for this tax season as it's coming up. First, just a little background on the Defense of Marriage Act. Most of you probably know that DOMA Section 3 was a federal law that prohibited the federal government from recognizing any marriages of same-sex couples, even if you're validly married in Massachusetts or any of the other New England states or in other places across the country. DOMA basically forced the federal government to pretend as if you were not married, as if you were single. And for tax purposes, what that meant is that for many years, married same-sex couples have had to file their federal taxes as single and then had to work create all these different workarounds to comply with this fiction that they were actually single and not married couples. We are very excited that in June of this year, or of last year, 2013, the U.S. Supreme Court finally decided that DOMA is unconstitutional, as Section 3 of DOMA is unconstitutional. And that was thanks to a lawsuit that the ACLU brought, which GLAAD worked in a large part on as well too. GLAAD was also the organizations that brought one of the first lawsuits against DOMA, the Gill challenges, as well as the Pearson challenges here in Massachusetts and Connecticut. So we've been working a long time on trying to defeat DOMA, and we're really excited now that there's a new dawn, basically, with regards to federal recognition of our marriages. So what does that mean for our taxes? So the quick overview is that if you were married starting on December 31st of last year, then you will be considered married by the IRS for the 2013 tax year. So that means that for your federal tax returns, on which you'll be filing probably for most people in April, you will be using the statuses of married filing jointly or married filing separately. Married couples basically can no longer use the single filing status on their federal tax returns, and that's really important. And we have had some questions, even from some of the folks who registered for this webinar, as to whether or not that is the case. Now, that does mean a few things. Filing married does mean a few things. First, the adoption credit that many of you guys had taken advantage of for your cross adoptions will no longer be available, unfortunately, and that was a big financial help for a lot of folks who were doing adoption. You can no longer claim your spouses as a dependent, although they do now qualify for the spousal exemption. If you are filing as married filing separately, and again, there's in order to determine whether or not that makes sense for you financially or not, there are some things you can look at, but ultimately you should consult with a CPA. But if you decide that's the way you want to go, both spouses must itemize their deductions or use standard deductions. And I realize this is something that I'm realizing that we're going to have to start doing even just for our joint taxes. I know that my husband Adam always had to itemize because he had a lot of business-related expenses, and I always just used the standard deduction because I didn't feel like keeping track of every single charitable donation that I made and whatnot. And now we're actually being forced to do the exact same thing. In filing for divorcing couples with at least one dependent child, they are just subject to different rules. So if the parents lived apart for the last 6 months of the year, and the custodial parent paid for more than half the cost of maintaining the household, that parent can use the head of household status, and the other parent would file as married filing separately. Again, if you have more questions about that, you can certainly type that into the chat box of this webinar. We can try to get to as many questions as possible. You can email us or contact GLAAD Answers, or you can consult a CPA. The best place to look, though, first is the very helpful FAQ that the IRS just issued for same-sex married couples. We have a link of that on the screen, and we will also be sending an email at the end of this webinar with with links to all the documents that we'll be referencing in this webinar. So, next question. What if I'm married but live in a state that does not recognize my marriage? Well, the IRS has adopted what we are calling a place of celebration rule, which is basically that the IRS will recognize your marriage regardless of where you live, even if you live in a state that doesn't recognize your marriage, such as Texas, provided that that marriage was validly celebrated in a state like Massachusetts that does allow same-sex couples to marry. So what does that mean? Again, if you were married on December 31st of the last year, regardless of where you live and in which state you live, you will have to file under one of the two married filing statuses for your federal returns. This was laid out in a revenue ruling by the IRS, 2013-17. There's a link here, and again, we'll be sending that out to folks. It's a little technical, it's a little legal. If you really are interested, please take a look at it. But it basically says that the IRS will recognize your marriage regardless of where you live. Now, the question with regards to your state filing status is a little bit more complicated. So first, for those of you who live in a state that recognize marriages as same-sex couples, there's no complications there. They will recognize you as married for your state returns. However, the biggest question is for those states that do not recognize marriages as same-sex couples, but also require that a couple file their state returns consistent with their federal returns. So many states have these general rules that say if you file as married at the federal level, then you have to file as married at the state level. But what happens if that state also has refuses to recognize the marriages of same-sex couples? So there are a few states that, even though they will not recognize, generally speaking, the marriages or same-sex couples or allow same-sex couples to marry in those states, they have issued guidance that they will recognize for state income tax purposes only those marriages. And those states are Colorado, Missouri, Oregon, and Utah, although I put a parenthesis around Utah because that is a situation that's very much in flux right now, if any of you have been following Utah in the news. So for those couples who are married in Colorado, Missouri, and Oregon, and possibly Utah, you should be able to file your state taxes as married. And in fact, you should be filing your state taxes as married if you are in fact married. However, the vast majority of the states that do not recognize marriages to same-sex couples will not allow you to file your income taxes, state income taxes as married, even if they have this general requirement of coupling your state status with your federal status. You can see the entire list of those states. I put Montana in parentheses because the guidance that they've issued basically says that they won't recognize the marriages of same-sex couples, but they're also not going to ask either, which is a little unclear. Again, if you have questions, please do contact a CPA, preferably one in those states, then that will be more knowledge about that specific state's law. And then finally, there are a few non-recognition states that haven't issued any clear guidance, and so we're waiting to hear more from those states, and those states include Arkansas, Pennsylvania, and West Virginia. This is a rapidly changing area of the law, so please do consult a professional. Also, anyone who may be part-year residents in a recognition state and a non-recognition state should seek competent tax advice because those returns will certainly be more complex to prepare. We just had a question as to what the state of Florida is, and I realize, is Florida not on this? Yes, so I left Florida on this. Unfortunately, I will have to get back to you, and we can send that out in an email to you separately as to what the state of returns is for Florida. Somehow that got left off my list.
Florida doesn't.
Actually,
Florida
yes.
doesn't have state taxes, so for income tax purposes, it's a non-issue.
That's right. So there are actually a number of states left off this slide, such as New Hampshire, Florida, etc., that don't have state income tax returns. So you're fine. And hold on one second as I advance to the next slide. There we go. What if I am a civil union or registered domestic partnership? So generally speaking, the IRS has issued guidance saying that they will not recognize a civil union or a registered domestic partnership as a marriage for purposes of federal tax returns. Now, there is some confusion around that, which Lillian will be talking about a little bit later, but if you want to take a look at that guidance, you can look at the IRS's FAQ for registered domestic partners and individuals in civil unions, and again, that will be sent in an email after the webinar. The next question. I think we may have been paying more in taxes than we should have because of DOMA. What can I do about that? Well, the good news is that if you believe that you have been financially harmed because of DOMA for the last 3 tax years, you are able to amend those tax returns and ask for a refund. So those are the tax years of 2010, 2011, and 2012. And generally speaking, the due date to file that is 3 years from the date that you should have or had filed the return. So for 2010, that deadline is coming up this April. So if you do think you may have been harmed in 2010, we do recommend that you consult with the CPA soon to find out whether or not it makes sense to file that amended return. For 2011 and 2012, you have a little bit more time. Now, you can pick and choose which years you amend those returns. So, for example, I could decide to amend my return for 2010 and file it as married, and then choose to keep my 2011 and 2012 returns the same as they are, which is single. So again, you may want to look at which years it would be financially advantageous for you to amend those returns, and then just choose those years where it is financially advantageous, and file amended returns for those years. However, if you do file amended return, you must be married for all purposes within any single year or on any single return. So I can't file an amended return for 2010 and say that I'm married for the tax rate purposes, but not say that I'm married for another purpose. You have to be married for all purposes. And so that is where it gets a little bit more difficult to determine whether or not you will actually be benefited or harmed financially by amending your returns. And so that is where it's a great idea to speak to your CPA who can help you manage this, such as Lillian Gonzalez. So there are some indicators as to whether or not you may be hurt or harmed by filing amended returns. And so now I'm going to hand it over to Lillian to talk about what those indicators look like, and so that can give you some guidance as to whether or not you should consult with a CPA.
Great, thank you, Janson, for that information. It really frames very nicely the opportunities that may exist at the current time, being able to actually avail ourselves of some benefits moving forward. So basically, in terms of some of the indicators about whether to amend the return or not, clearly the perspective at this point is not just a financial one, but there's also a piece that has to do with legal issues with respect to filing a joint return. And this is really very, very important to consider, because oftentimes it really looks nice having the opportunity to have both spouses' names on the tax return. But one of the things that's happening as you're signing both names to the return is that both taxpayer and spouse are going to be equally liable for the items that are on that return. So if there's a large refund, clearly the person might want to say, this is my refund. But if there's a liability due on the tax return, that liability is equal to both parties. So each taxpayer and spouse are 100% liable for the liability, and clearly also for the accuracy of the information that is on those returns. So clearly it's an important consideration if there's some potential areas of concern with respect to the tax return. So that's one of the non-financial pieces that needs to be discussed between the two parties. So then taking a look at this is one of the few times in history that the IRS is going to give us the opportunity to go back and amend returns and have some levels of potential inconsistency between a taxpayer and a spouse. And as Janson said, we have the opportunity to take a look at 2010, 11, and 12, and oftentimes the situation from year to year may change quite dramatically. Well, how is it that we begin to determine whether we've got the opportunity to save some money with respect to the returns that had been filed? Well, if you had filed jointly in Massachusetts, you probably prepared a mock federal return. And that mock federal return is the beginning point in determining whether there may be some levels of tax savings for filing the return jointly. Clearly, there's some adjustments that may need to be made. So, for instance, if you had imputed health, you may want to make that adjustment and correction on that tax return. If you had adoption credits, that also needs to be factored in to see whether the loss of that adoption credit or potentially earned income credits is going to create a situation where filing a joint return you would owe more money. But typically, if you have a disparity in income between the taxpayers, that is an indicator that there may be some tax savings in filing an amended return. One other piece, and I think this question has come up also, having to do with what we would have considered at the time very good tax planning. You have one high income wage earner, and then you have a lower income wage earner. We're very attuned to the Roth contributions that many taxpayers have made to save money on their taxes. And the beauty of a Roth is that you can put money in, and even though it grows, you don't pay any tax when you take it out on the earnings that Roth IRA may generate. So this is a terrific planning tool. But what happens is that that Roth contribution is subject to income limitations. So once you merge the returns, that Roth contribution may kick out in a way that you're no longer eligible to make that Roth contribution. And this has happened with quite a few of the amendments that we've been looking at. And we just got clarity from the IRS last week on this issue, because we thought maybe they'll just pass on the penalty for having over-contributed to that Roth during those years. And what they said is that this needs to be factored in when you're making your determination of whether to amend or not. You have to calculate what's considered a 6% penalty on that contribution for each year. So if you're looking to amend 2010 and you put in $5,000, a 6% penalty would be $300 for 2010. And that would continue on for the 11 and 12 year as well, as long as that contribution stays within that Roth. So anyway, this is again something that they gave clarification very, very recently. And that particular penalty is statutory, so there's nothing that can be done to get rid of it. So essentially, really taking a look at that mock return is the starting point. And if you did not prepare that mock return, then you will have to merge the two returns into one and see where the numbers fall, again, having made all those adjustments. Now, if you want to amend the return, basically you use a form called the 1040X. And on the top of that form, you need to state, filed pursuant to Revenue Ruling 2013-17. And the reason that this is important is because it's letting them know that the marital status is changing on the return. And as Janson mentioned, everything on the return needs to be adjusted for the marital filing status. The other piece that's
So Lillian, can I stop you for one quick question?
Sure.
Going back to the last slide, you mentioned that a large income difference might be an indication that you were harmed by DOMA and should amend. Is there a general rule of thumb as to how large an income difference it should be?
Generally, if it's under $144,000 worth of income, that's just sort of a benchmark to take a look at it, whether to go through the exercise of figuring it out. So the income differentials, the closer the income is to each other, the chances are that you probably fared better by filing singly. But what happens is the way the rates, the married filing joint rates are, is that, and the single rates, is that typically up to the 25% tax bracket, essentially the single rates are half of what the married filing joint rates are. So once you go over the 145,000, you end up on a married level getting taxed somewhat higher, which is the infamous marriage penalty.
Great, thank you.
Sure. So in terms of filing the amended return, basically you do say that you're filing it pursuant to this particular ruling. And what's important about this is that oftentimes if you have certain carry forwards, like passive loss carry forwards, or you have capital loss carry forwards, and as Janson had mentioned, you can pick and choose what years you're going to amend. If you've got a carry forward from the 2010 year to 11, and then subsequently to 12, but you're only amending 2010, the carry forwards for 11 and 12 will not be correct. And so you have to go back and amend the 11 and 12 tax returns, but not for the marital status. So those are just normal amended returns. Now this is an unexplored area. We call Chief Counsel's office on amending returns just merely for a change in carry forward, and they said that this would be allowed. But for some of you who may have already called the IRS on a variety of issues, they always tell you can't rely on what we tell you on the phone. So, but they're also not willing to give us in writing that this is their position. So we're sort of pushing on Chief Counsel's office to give us some written guidance so that we can rely on that guidance. But unofficially, that's what they have determined in terms of filing those amended returns. What is really important to pay attention to with respect to these amended returns? Well, clearly, as Janson had mentioned, that basically everything on the return, if you're filing pursuant to this revenue ruling, that everything on the return, you have to apply the marital limitations for that return. Everything needs to be changed. So as I expressed earlier, with the Roth contributions, that may impact the actual calculation of the tax. Same thing with the earned income credit. So essentially really being very, very careful about how this is being done. It's really important also to realize the opportunity that we have here is that for these amended returns only, not moving forward, but through 2012 when you amend, one spouse can amend their return to married filing separate, and the other does not have to amend their return. So the level of consistency that we need from the 2013 year moving forward is not applicable to those amended returns. Same things with the itemization. For that period of time, you can have one married filing separate, itemizing their deductions, and the other does not have to itemize. The other piece too is in terms of the adoption credit. That is also, you have to be very careful because those were refundable credits, and if it's for an adoption that is for a child that wasn't in the home or born into the marriage, then those adoption credits will remain. But if it's a cross adoption between the couple, then those adoption credits will be lost at that point. Also, one important thing is those taxpayers who may have divorced their spouses from 2010, 11, and 12, they may have been paying alimony payments which were non-deductible on a federal level. They can go back and amend those returns for those years to take that deduction. And so, in essence, if we can't take the if the other partner does not have to if the partner does not want to take that income, it's okay to not take that income in, and you can still get the full deduction of the alimony, which is a really nice benefit. But that will not be the case moving forward from 2013 on. Understand that the rules that are applying for those 3 years in particular will not be the case moving forward. There will have to be consistency. And in terms of how the IRS has been dealing with this, we've been spending a lot of time trying to help the IRS understand how to process these claims. We sent in some protective claims for the 2009 year. Now, a protective claim is it's a process that it doesn't appear in the tax code or regulations, and these are used when the right to a refund is contingent on a future event, such as pending litigation or a regulatory issue, and that will be resolved at some future date. Filing the protective claim preserves the taxpayer's right to obtain a refund. So for the 2009 year, the statute of limitations was about to expire in April 2013. Knowing this and knowing that the Windsor case had been heard and there was a decision that would be entered in June, what we did is file some protective claims for those clients we believe would receive a refund to tell the IRS, hold our place, we don't want the statute to expire on our capacity to earn a claim because we don't know how the Supreme Court is going to rule. So essentially those were sent in by April 15th of 2013. And we've just started, we had out of 19 that we filed, we had 3 that have been processed properly, 2 that were improperly processed, and we're still working on the other 14 that are now being assigned at this point. So the process has been very, very slow. We're trying to figure out now in terms of submitting some of these returns and whether to send in, if you are amending all 3 years, whether to send them together. Different practitioners have different opinions about that. So you can, if you're submitting 3 years worth of amendments, it may make sense to just send them all together because that way one agent may be assigned all 3. But if the amounts of the refunds vary, from what we've heard unofficially is that refunds of specific amounts are sent to different service centers. So they may get pulled apart. Very important as you're actually submitting these claims that you provide as much, if you're going to do it yourself, which I generally don't recommend because there's a lot of information that needs to go with that so that it gets processed as efficiently as possible. But if you're going to send those in together, send as much as you can, and you know, you need to make the choice whether to send them in together or to send them in serially within a say a 12-week period from each other.
Lillian, can I just interrupt you for 1 second?
Sure.
So we just got a few questions about binational couples who are married or couples who married out of the country. And I'm not aware of any reason why those marriages should not be recognized in the same way as marriages of two U.S. citizens or marriages that happen in the U.S. So unless there's a more specific concern that the folks have, even if you're married in Canada, that marriage should still be recognized by the IRS.
That's absolutely right, and that I think that Edith Windsor and they were married in Canada, as a matter of fact. So I suspect, so long as it's a recognition country, that there should be no issue at all. In terms of community property states, we've actually been dealing with a lot of community property issues out in California, and those returns are very, very complicated to prepare because the rules are somewhat different. But the one thing that I did want to highlight is there is information if you do live in a community property state. There's publication 555 that's available with worksheets to help you work through those pieces. They try to define what's considered community property, what is not community property, and typically it will defer back to the home state. So if you do live in a community property state, you can certainly take a look, like in Texas. If you live in Texas, they have their specific rules of what's considered community property and what is not in the assistance of preparing your own tax returns. But the one thing I do want to highlight with respect to CP property is that if you live in a non-community property state, you move to a community property state and then back to a non-community property state, while you are living in that community property state, we define again what is community property and what is not moving forward. So it's not like it loses its characteristics when you move out of state. So it's something very important, which I learned not too long ago. One of the things...
So Lillian, sorry to interrupt you one more time. Before we move on to the next slide, we were having a little technical difficulty before, and we missed this slide right here. So some people were asking if we could see it again, which is for the amended returns, you'll be filing using the 1040X, and you would write at the top of the form, filed pursuant to Revenue Ruling 2013-17. That slide is now on your screen. And then, of course, this entire PowerPoint we can send to folks after the webinar in an email. Sorry to interrupt you, Lillian, but back to the community property slide.
Great. Okay, so now I'm on to the imputing the income on the W-2. Essentially, this is one of the areas where most couples have suffered, is having to pay income tax on the health benefits for a spouse. And most employers have placed that information on the W-2 itself, and it's listed under imputed income in box 14 of the W-2. Now, some employers have actually gone back and amended the returns for 10, 11, and 12. Others have chosen not to correct that information. Now, in terms of getting the income taxes that were paid back, that were paid on that imputed income, basically you do have to go through the amendment process to recover that. So that is not dealt with as something separate from an amended return. So if you don't have the W-2C, and that's the corrected W-2 because your employer is not issuing it, what you need to obtain is enough information to show what that imputed income was. Usually the last pay stub of the year may indicate what that amount is, and that would be placed on the tax return, and it can become an adjustment to the income so that you can at that point obtain that refund. But again, if you're going to try to obtain the income tax, you have to amend the whole return for everything, and that's where you need to make that evaluation whether it's worth obtaining. The second thing that was paid on that imputed income is the employment taxes. And the employment taxes are made up of two items. One is the Social Security tax, and the other is the Medicare tax. And the Medicare tax is 1.45%, and that's applied with no limitation on the income. So essentially, you're taxed on that no matter how much money you earn. On the Social Security side, or the FICA side, that basically has a limitation. For 2010 and 11, it was $106,800. For 2012, $110,000. $1,100. The Social Security tax rate was 6.2% in 2010, and it reverts to that in 2013. And for 11 and 12, the percentage is 4.2% for 11 and 12. So you can actually go back and get that employment tax that was paid through a Form 843. What they ask is that you put Windsor claim on the top. So if your earnings are $140,000 and you have imputed health benefits, chances are all you're going to get back is the 1.45%. And basically all you have to, the information that you have to put as an explanation on that is that your employer is not applying for that refund. And that's the basic process for obtaining those taxes back. In terms of other employment...
Quick question, Lillian.
Yes?
There was one question as to whether or not they needed the amended W-2s in order to collect back for the taxes they pay on the imputed income.
They do not need the W-2C. It may make it a little bit harder, so that's why having the last pay stub of the year that shows that the income was imputed, or getting a statement from the HR or payroll department that says this is how much was imputed income for these particular years, again on the company stationery, would be helpful. So I think any additional proof that the income was imputed would probably be sufficient. Just one other aside on this. The IRS has been instructed that these amended returns are to be processed by the examination division. As soon as we heard that, the hair stood up on our necks, because we're thinking, oh my God, they're going to start auditing these returns. And they have been instructed that these returns are not to be audited unless you're also amending for some other reason. So if you said all of a sudden, oh gee, now I want to deduct, $40,000 of medical expenses, they can audit that issue, but not the filing of the amended return. One other piece, just to go back on the amended return, sometimes there's been requests for marriage certificates, and we have clients who are on both sides of that issue, whether they have the right to ask or they don't have the right to ask. And we let the client really decide what they'd like to do. The IRS, it appears, has the right to ask for any item to justify making a change on the return, or to justify a deduction, or any selections or elections made on the return. So if not providing it is going to delay the refund, those are the considerations to be made when deciding how to respond to any IRS requests. In terms
and Lillian, what about the question of whether or not to file all three of those amended returns at once, or should they do them, separately? I realize it's a lot of work to do in the next 3 months to reach, do maybe all three amended returns.
Well,
especially for you.
That's right. From a practitioner's perspective, it makes sense to actually be able to do them all at once. And we've heard, a lot of different opinions about this. A lot of practitioners are saying do one at a time. The statute of limitations for the 2010 year will close for most people April of 2014. So there is a certain rush to get the 2010 year done. If there are no carry forward issues, there is no I don't feel personally that there's any reason not to file them all together. As I said, the only thing is that if the refund amounts are different, they may be sending it to a different service center. So we try to make sure that all the packets are complete, including everything that needs to be in there. Even though it may duplicate some data that would apply to all 3 years, we just photocopy it again and make sure that it's in each of the packets. So I think it's really a matter of the practitioner's choice and also the taxpayer choice which way to handle that. And the IRS really has not said, although they've recommended send them separately, but I think it just delays the process. If you have one examiner dealing with 3 years, it may help the process go a little smoother. So at this point, it's too early in the process to really tell. In terms of the cafeteria plans, and basically what the cafeteria plans are plans that allow you to take a cash benefit or to have a certain type of benefit. For instance, you can select to have dependent care benefits, so that the maximum is $5,000, so that you can apply that to child care expenses. You can have what's called flexible spending accounts, which are generally for medical expenses. So now all these cafeteria plans and retirement plans have to open up in its entirety to the taxpayer's same-sex spouse as well. Now, I think for most of these, starting in the 2014 year, it's across the board. Some cafeteria plans allowed changes as soon as the Windsor decision came in. All the changes were made. Most employers did retroactive adjustment of the health insurance for the 2013 year. The IRS had issued some regulations with respect to processing those adjustments on the employment tax returns. So I think for the most part, not everybody, but for the most part, the employers complied to make sure that that was available. And many employers allowed a change in marital status so that elections that have been made that typically can't be changed during the year were able to be made in a timely fashion. And I believe since most of the guidance came out with respect to the cafeteria plans, the IRS notices and rev rulings, I believe that many started to incorporate. Although the larger companies, it always takes a long time to go through compliance and their legal department. So some of these may be a little slower in making these changes. But clearly, in terms of some of the pension plans and 401ks, et cetera, and those that are governed by ERISA, since that's federal regulation, irrespective of the state that you live in, and I'm going out on a limb a little bit, but I think that most plans that meet those requirements, it doesn't matter what state you live in, but that if you have a same-sex spouse, they will have to honor that in terms of the plan procedures and elections. Now, just to switch a little bit on the gift tax, and I'm going to do the very quick presentation on gift and estate taxes. Basically, most of us are very familiar with the income tax because we have to interface with income tax every year. Most people by April 15th. With estate and gift, it's a little bit different, and estate and gift has to do more with assets rather than income. Essentially, what happens in a nutshell with gift and estate taxes is this. For estate taxes, for federal purposes, the maximum limit, the exclusion is $5.25 million before you have to start paying estate taxes on your assets and or your net estate, which is your assets minus your liabilities. On the Massachusetts level, it's only $1 million, so there's a huge gap here. So this may not apply to you on a federal level, but there may be some state issues that you need to, state estate issues that need to be dealt with in your planning. So basically with the gift taxes, the way it works is this. The IRS says, you know what, you can give money to anybody you want, as much as you'd like. We're going to allow you in the, I believe it was in the 2010 through 2012 years, $13,000 a year, and for 13 and 14, it's $14,000 a year. So you can give anybody, let's say in 2013, $14,000. You don't have to do anything. It's just a de minimis gift, and it's all done. But if you decide that you want to give that person $113,000, then what happens is this: that first $13,000 is considered de minimis, but the additional $100,000 is going to impact your lifetime exclusion for your federal estate. So that $5.25 million is going to be reduced by $100,000. So every time you give money away in excess of that amount, something happens against or you start reducing your lifetime exclusion. So many same-sex couples, because you did not have the capacity, to transfer money to your spouse, because spousal transfers, no matter what amounts they are not considered a taxable transfer. You can give as much money as you want without having to file any gift tax return. So since the marriages were not recognized, many of these spousal transfers were considered by the federal government non-spousal transfers. Gift tax returns were prepared, and by utilizing those gift tax returns, part of that lifetime exclusion was utilized. So now those people who've been filing those gift tax returns, you can go back and amend those gift tax returns, and essentially all you have to do is reprint out that form, place it down as a spousal transfer, and then just put down amended return on that particular return. And it really is recommended to go back and make those amended returns so that you can restore your lifetime exclusion. The same thing in terms of the marital exemption to the estate tax. If you have anyone who died starting in 2010, you can go back and refile any estate tax returns that have been prepared, just like Edie Windsor did, to obtain back any estate taxes paid. And this week, actually, you got some clarification. There's this portability feature that was entered into the tax law in 2010. And just simply stated, it means this. Each person has $5.25 million worth of an exclusion for their estate before you pay estate taxes. If your spouse doesn't use it, you can assign it to your spouse. So if you have somebody who dies with nothing and they elected on their estate return, even though they didn't have to file, they just elected to pass it to their spouse. Essentially, 5.25 turns into 10.5 million. Now, for many, it might seem like, oh, well, you know what, I don't have that much in assets. But my thing is, you never know. What if you won the lottery? And that might come in useful to save a little estate tax. So now we're allowed through the end of 2014 to actually go back and file and make that election on those returns. And just as a very brief summary of some of the things that are still outstanding, we don't know what's going to happen with those gift tax returns that were filed before 2009. Even though the taxpayers may still be alive, we don't know if the IRS may come back with some recommendation on the estate return itself to be able to restore that in full. I just talked about the portability of the estate tax exemption. That just got resolved, as I said, this week. In terms of the civil unions, just so that you know, Connecticut automatically considered past civil unions as same-sex marriages. So we're not quite sure whether that statement by the IRS that all civil unions are not considered marriage will hold in this case. Same thing in Illinois. The Chief Counsel's Office had allowed opposite-sex couples that were in an Illinois civil union to file jointly. So we're not sure whether that's also going to extend to same-sex couples, and the same thing for Nevada, where they have similar laws as Illinois. Again, the unexpected tax consequences for certain tax transactions that were entered into between spouses who were considered at the time not married and not related, those things may be recast. Now, this is a little bit more limited, but again, there's just a lot of unresolved areas that may have some substantial tax consequences. The issue of the carry forwards, again, they answered this question last week, so now we know that you can actually go ahead and amend a return for a year that you're not amending just to change the carry forwards. But again, we don't have anything in writing yet. There's additional items that we need to be thinking about, and I think, Janson, you're probably going to talk about some of these things.
That's right. But before we move on away from taxes, there's just a few questions that I think have come up, and just bear with me as I'm scrolling through some of these questions. The first one, actually, with regards to the civil union question, Lillian, that you just talked about, for those couples, such as the couples in Connecticut who had a civil union merge into a marriage, your status is now married. Your status is not a civil union anymore. So we don't expect that the IRS would treat you. The IRS should treat you as married for purposes of your federal tax returns. And that's not just Connecticut, but also states like New Hampshire also merged those civil unions into a marriage. And that's because literally your civil union at that effective date went away, and now it's a marriage. But that doesn't resolve the question with regards to those opposite-sex civil unions in Illinois, where there seems to be some confusion from the IRS. Hold on one second. All right, so there was one question that I think, let me see if I can understand it correctly. There was a question from a person who was saying that she and her wife filed their 2010 taxes separately or single. One of them got a refund, the other did not. and they were asking whether or not the one who did not get the refund could amend the returns, while the one who did get the refund could not amend the return so she could retain the refund. And so, Lillian, before you jump in, let me take a shot at this, which is that if one of you amends the returns as married filing jointly, then that married filing jointly is now amended return for both spouses. That's a joint tax return. So by amending quote unquote one of your returns to be married filing jointly, you really are amending both your returns as married filing jointly. And I think the bigger question there, and I'm not sure if this is what the questioner was asking, is whether or not one spouse could amend their return to be married filing separately, while the other spouse can retain the single return from 2010.
Yes, I think they can. That's the level of inconsistency that we can have for those 10, 11, and 12 years, is that one can amend and the other not amend. But if they're amending, you have to, and you're doing it separately, it has to be married filing the and the other spouse does not have to amend.
Great, thank you. So then, moving on to another set of questions that we've had. There are a number of questions still about the IRA Roth, and instead of trying to consolidate them or rephrase them, I think I'm going to just read them out loud to you, Lillian, if that's okay.
Sure.
So here's one of them. Does the IRA penalty apply to non-Roth deductible contributions as well?
Well, basically what you can do is if you took a deductible traditional IRA and you can no longer deduct it, then it just converts into a non-deductible. It's the same IRA, it's just you're not deducting it. And then you just need to make sure that you account for the basis in that. So that means that when you take that Roth out, that IRA out in the future, that you don't pay tax on it at that point. But you can do that, and the penalty will not apply in that case.
Great, thank you. So with regard to the penalty, another question asked if the penalty would compound from year to year, such as if you paid $300 for 2010, you pay $300 again in 2011 and again in 2012. So you're ultimately paying quite a bit of money.
Right. Ultimately, you're right. It is a compounding factor. So if you're amending 2010 and that's the only year you're amending, and there was a $300 penalty and you're not going to withdraw it until now, the penalty applies to 10, 11, and 12, and you have until April of 2014 to not pay that penalty.
Great, thank you. And then the last question, which I think I can answer, let me take a shot at it. Does the Roth IRA contributions made need to be quote unquote recharacterized? And I think what you're asking is, do you have to go ahead and amend your past returns to recharacterize the Roth contributions? And as we had said in the beginning of the training, you can choose not to amend your returns for 2010, 2011, 2012. That's entirely your choice, and what would determine whether or not it's advantageous for you or not is whether or not it's all the different things we talked about in this webinar.
Can I just add one last item on the Roth? And I think this is something, because oftentimes people will take a look and say, well, you know what, I'm going to get a $1,500 refund, but I have a $300 penalty. Okay, it makes sense. I'm still making out $1,200. But the answer may be different depending upon the age of the taxpayer. Because what happens is if you take a look at, and if you're in your 30s, that Roth contribution may end up really mushrooming into a very large number, and the tax savings in the long haul may be greater than the tax savings to amend. So it's something that I would recommend, again, depending upon your age, to have your investment advisor run some numbers for you so that you can make an informed decision, because it's not just about the taxes.
Great, thank you, Lillian. So I'm sorry, if you just bear with me for a second, there are a number of questions still coming in, and I'm just reading through them. A lot of the questions I'm not addressing, partly because they were answered a little bit earlier. I realize there's a ton of information in this webinar, and so one thing you may want to do is just to go back to the recording after this is done. You can follow along by the slides to find the topic that you had your question in, and hopefully by going back you can find the answer to your question.
I can also make myself available
And
if there's anything specific.
thank you, Lillian. That was another thing I was going to add as well, too, is that we have a list of all your questions from this webinar. And so we'll also take a look at those questions, see if there's any that haven't been answered by the webinar, and then we can also reach out to you directly with some answers. And thank you, Lillian, for making yourself available. Of course, you should, you can and should contact GLAAD Answers, which is GLAAD's legal information service here, and our very last screen will show you how, and we're always available to answer your questions. Give me one more second as I read this one last question. Well, I'm just going to read this one out loud, Lillian. If we want to file as married filing jointly on a 1040X, what goes in column A, B, and C? I.e., is A the sum of our single numbers, C what it should be as married filing jointly, and B the difference, and B is the difference between the two. Also, which one of the two of us files a 1040X, or do we both have to file? So I definitely know there's an answer to the last question. The first question I didn't fully understand. I'm not sure if you got it either.
Right. Basically, somebody's going to be the taxpayer, one person's going to be the spouse. So the original, whoever the taxpayer is, their information is originally filed goes in column A. And I believe in column B, it's the change between the two, and C is what the end result should be for the joint return. So essentially, one of the things we do is send a bridging document, is there has to be a way of getting from A to B to see. So in column, what I would do is just send an Excel spreadsheet that shows the taxpayer, and then the column B is the spouse's information, have the adjustment column, and that should equal your column B.
Great, thank you so much, Lillian. So we're going to just go on to our very last slide here, which is there anything else beyond taxes that I should be thinking about? So obviously DOMA affected a broad range of federal programs beyond taxes, and in fact it affected 1,138 federal statutes, and some of the biggest federal programs we have, like Social Security. And there's been a lot of guidance coming out from the federal administration, the Obama administration, and there is still more coming out. So this is a very fluid area of law, and we really recommend that you stay updated at glaad.org/DOMA. Also join our mailing list, and then of course contact GLAAD Answers, since we are literally getting new information from the administration every week. That being said, there's some terrific guidance that we've gotten from many of the agencies. So if you remember, one of the biggest questions was whether or not the federal government would recognize your marriage, even if you lived in a state that did not recognize that marriage. And we have been advocating for the administration to adopt a place of celebration rule for as many programs as possible. And they have done so for benefits, employee benefits like COBRA and HIPAA, for immigration benefits to be able to sponsor your binational spouse. For federal employee benefits, the federal government has made clear that you are married regardless of where you live. There are some programs, such as FMLA, where the federal government has provided guidance saying that you have to live in a state that recognizes your marriage. Finally, we are still waiting for more information from Social Security as well as veterans benefits. Social Security is probably the biggest source of questions we get in addition to taxes. We actually just did a webinar on Social Security just last week, and so I very much recommend if you have questions on Social Security, please check out that webinar on glaad.org. And then finally, the other area where we've gotten a lot of questions with regards to FAFSA. So basically, the financial, for 2013 and 2014, changes were made requiring same-sex couples that were married in a recognition state and the students' legal parents to include all their financial information. So for the 2013-2014 FAFSA form, if you were married, regardless of where you lived, both spouses' information need to be on that form. For 2014-2015 FAFSA forms, it doesn't matter whether the two legal parents were married or not, provided that both of them are legal parents and they live together they must report their income on the FAFSA form, regardless of the marital status. So that is a change coming from the Department of Education that people should be aware of. Again, this is a rapidly changing area of law. We very much encourage you to contact us at GLAAD Answers. Look at our website. We have an updated publication with regards to all these changes. If you're looking for experienced and qualified CPA, we very much recommend you contact Lillian Gonzalez. And if she can't help you, we can also give you some other referrals too if you contact us at GLAAD Answer. You can call us, you can chat with us on our website, and you can also email us as well. So this brings us to the end of our hour. I just want to thank you all for joining us. I really hope that this was informative and helpful. I want to thank Lillian Gonzalez again for all of her expertise and information and advice, information on the subject. And again, please contact us if you have any other questions. Thank you so much.
Thank you.